Hi everyone, I'm Sam, and today we're going to talk about medical law. When we talk about healthcare, what often comes to mind first is professional skill and scientific judgment. Doctors diagnose illnesses based on symptoms, prescribe medications, or arrange for surgery. Patients, in turn, trust the doctor's expertise, undergo treatment, and hope for a quick recovery. But healthcare is not merely a technical interaction. It also involves risk, choice, unequal access to information, and even control over life itself. When these issues lead to disputes, the law steps in, right beside the hospital bed, to clarify responsibilities and protect rights. This is where medical law comes in. It addresses more than just whether a doctor has fulfilled their professional duty. It also considers whether patients fully understand the risks of treatment and have had the chance to make their own decisions. Topics within medical law include medical negligence, informed consent, reproductive rights and abortion, end-of-life decisions, patient privacy, and the boundaries between public health and state authority. Medical law is not only a technical tool, but also a reflection of how a society understands the body, autonomy, and the value of life. When dealing with disputes over medical negligence, the law typically follows a clear four-step structure. First, it must be established whether the medical professional had a duty of care toward the patient. Second, the court examines whether their actions met the required professional standard. If that standard was not met, this counts as a breach of duty. The third step is to determine whether there is a causal link between that breach and the patient's injury. Finally, only if the patient suffered actual harm as a result does it qualify as legal medical negligence. These four elements, duty of care, breach of duty, causation, and actual harm, form the basic framework for assessing medical liability. Yet in practice, each element can be subject to debate. Who sets the standard of care? Did the doctor exercise reasonable caution? Was the harm truly caused by that specific medical decision? These questions often require expert witnesses and legal proceedings to resolve. Through this structure, the law tries to create workable rules within the complexity of medicine, rules that give victims a chance for compensation while holding healthcare professionals accountable within reasonable limits. From a legal design perspective, it's a balancing act, encouraging caution and professionalism without punishing normal medical risk. That balance lies at the very heart of medical law. In the early 20th century, the state of Massachusetts was facing a smallpox outbreak. At the time, smallpox was still a deadly and highly contagious disease. To prevent the spread of infection, the city of Cambridge issued an order based on state law requiring all residents to get vaccinated or face a fine. This policy was met with resistance from a local resident, Henning Jacobson. He had been vaccinated as a child and claimed to have suffered adverse effects, so he refused to be vaccinated again. Believing the order violated his personal freedom and constitutional right to bodily autonomy, Jacobson filed a lawsuit asking the courts to overturn the mandatory vaccination policy. The case eventually reached the United States Supreme Court. In 1905, the court ruled in a 7-2 decision in favor of the state's mandatory vaccination policy. The court held that the freedoms protected by the Constitution are not absolute, and in certain circumstances, the government has the authority to limit individual actions to protect public health and safety. In the face of infectious disease threats, it ruled, the government can take reasonable and necessary public health measures, including compulsory vaccination. As long as there is sufficient medical evidence supporting the vaccine's effectiveness, such a policy is both constitutional and justified. This decision became a landmark in American public health law. It established the legal principle that, in times of serious health risk, the state may lawfully impose limited restrictions on individual freedoms to protect the broader community. The Jacobson case did not reject personal rights. It clarified that during public crises, those rights must be balanced against the collective good. The legal impact of this case has lasted for over a century. During later outbreaks, such as measles, influenza, and even the COVID-19 pandemic in the 21st century, governments repeatedly referenced this case to justify public health policies like vaccine mandates, lockdowns, and mask requirements. The debate sparked by Jacobson remains unresolved. When an individual's choices may put others at risk, where should the boundaries of freedom be drawn? This question continues to challenge modern medical law and public policy. In 1914, a woman named Mary Schloendorff was admitted to a New York hospital due to abdominal discomfort. Her doctors suspected that she might have a tumor in her uterus and recommended further examination, also raising the possibility of surgery. However, Schloendorff clearly refused any surgical procedure. She consented to an examination under anesthesia, but firmly declined the removal of any organs. While she was unconscious, her doctors proceeded, without her consent, to remove the uterine tumor. After the surgery, she suffered serious complications, including infection and partial paralysis. She then sued the hospital, claiming that the doctors had violated her wishes and infringed upon her right to control her own body. The case made its way to court and sparked a broader discussion about patient rights and the boundaries of medical practice. The presiding judge, Benjamin Cardozo, wrote a now famous line in his ruling: "Every human being of adult years and sound mind has a right to determine what shall be done with his own body." This statement became one of the earliest and clearest affirmations of bodily autonomy in American medical law, and it marked the beginning of what is now known as the principle of informed consent. The court ruled that even if doctors act with good intentions, they are not permitted to perform major medical procedures without the patient's explicit consent. Performing surgery without permission, even if the outcome is beneficial, can be considered a legal violation, amounting to battery or unlawful physical contact. The ruling sent a clear message: medical decisions cannot override a person's will, and professional judgment must be grounded in respect for the individual's right to choose. Although Schloendorff was ultimately unable to receive compensation from the hospital due to the charitable immunity doctrine in place at the time, the case had a profound and lasting impact. It brought the concept of bodily autonomy under legal protection and provided the first systematic legal argument that medical procedures must be based on personal consent. This not only affirmed respect for individual dignity, but also laid the legal foundation for the modern doctrine of informed consent in both medical law and ethics. From that case forward, patients were no longer seen as passive recipients of care, but as active participants with decision-making power and legal protection. This perspective gradually gained acceptance in both the medical and legal communities, and is now a fundamental part of modern healthcare. After the end of World War II, as the Allied forces investigated the war crimes committed by the German regime, they uncovered a harrowing chapter in medical history. In concentration camps across Germany and the occupied territories, physicians under the Nazi regime had carried out a large number of involuntary and inhumane experiments on prisoners. These included exposing people to extreme cold, injecting deadly viruses, forcibly altering blood types, and even performing surgeries without anesthesia. These acts were carried out without the subject's consent and showed a complete disregard for human life and dignity. The goal of many of these experiments was not scientific advancement, but military research, racial ideology, or outright cruelty. These atrocities became the central focus of the 1946 Nuremberg doctors' trial. In this historic trial, 23 physicians and medical officials associated with the Nazi regime were prosecuted. Many were convicted of crimes against humanity and war crimes. But the trial did more than assign blame. It sparked a global reckoning with the ethical responsibilities of medical research. After the trial, the panel of judges, led by the United States, outlined 10 foundational principles for ethical human experimentation. These became known as the Nuremberg Code. The most important of these principles is voluntary participation. The code clearly states that no human experiment should be conducted without the freely given, informed, and explicit consent of the subject. In other words, participants must fully understand the nature, purpose, potential risks, and outcomes of the research, and must agree to participate without any coercion or deception. Beyond informed consent, the code also requires that experiments be grounded in sound science, aim to produce beneficial results, and minimize both physical and mental harm to participants. Although the Nuremberg Code is not a legally binding treaty, it laid the ethical groundwork for modern research regulations. It was a direct response to the horrors of Nazi medical crimes, but also a broader declaration. Medical practice must always be governed by both ethics and law. In the years that followed, countries around the world began establishing their own rules for clinical trials, including mandatory review by ethics committees to ensure that research involving human subjects is both morally and legally sound. The principle of informed consent, first articulated in the Nuremberg Code, became a global standard for medical research and has since extended into everyday clinical practice. It serves as a powerful reminder that no matter how advanced medicine becomes, it must never lose sight of respect for individual autonomy. Since that post-war reckoning, one simple yet profound question, "Are you willing?" has stood at the heart of both medical care and scientific research. In 1972, a young man named Jerome Canterbury sought treatment from Dr. Spence in Washington, D.C., due to persistent back pain. The doctor recommended spinal surgery and described it as a routine procedure with minimal risk. However, after the operation, Canterbury was left paralyzed from the waist down. He later discovered that the surgery did, in fact, carry a known risk of paralysis, something he had never been told beforehand. Believing that he might have chosen not to undergo the surgery had he known this risk, Canterbury filed a lawsuit, arguing that the doctor had failed to provide the necessary information, thus depriving him of the right to make an informed choice. The case reached the U.S. Court of Appeals for the District of Columbia Circuit, where the judges made a pivotal decision that reshaped medical law. They ruled that medical decisions should not rest solely in the hands of doctors, but must empower patients as the ultimate decision-makers. The court held that physicians must disclose all information that a reasonable patient would consider important. This includes possible risks, alternative treatments, and the consequences of forgoing treatment altogether. This standard marked a clear departure from the traditional physician-based model, which only required doctors to share information that their peers would typically disclose under similar circumstances. The new reasonable patient standard asked doctors to see things from the patient's point of view and to share the information needed for an informed decision. The Canterbury case was not just a single malpractice lawsuit. It marked a turning point in the evolution of informed consent. Historically, medicine had been a profession-led domain, where patients often passively followed instructions. But this case emphasized that patients have the right to participate in every major decision affecting their health. Informed consent is not just a formal procedure. It is a meaningful act that allows patients, as thinking individuals, to weigh risks and make choices for themselves. Following the ruling, courts across the United States gradually adopted this patient-centered standard of informed consent, and its influence spread to healthcare laws and ethics training around the world. From then on, doctors were expected not only to diagnose and treat, but also to communicate risks and guide patients through their choices. Patients, in turn, were no longer seen as passive recipients of care, but as active participants with the right to agree, choose, or even decline treatment. The Canterbury decision transformed informed consent from a legal obligation into a foundational principle of the doctor-patient relationship. It made clear that good medicine begins with respect for the patient's wishes, and it laid the ethical groundwork for modern medical practice. In 1973, the United States Supreme Court issued a landmark ruling in a case known as Roe v. Wade. The case was brought by a woman in Texas using the pseudonym Jane Roe, who challenged the state's near-total ban on abortion. At the time, Texas law only allowed abortion if the mother's life was at risk. Even in cases of serious health concerns, abortion remained illegal. The plaintiff argued that such restrictions violated her fundamental freedoms as a woman. In a 7-2 decision, the court ruled that the constitutional right to privacy includes a woman's decision to terminate a pregnancy. Citing the 14th Amendment's protection of liberty, the court reasoned that personal control over one's body and private medical choices fall within the scope of basic freedoms. The court introduced a trimester-based framework. During the first trimester, the decision to have an abortion rests entirely with the woman and her doctor, and the state may not interfere. During the second trimester, the state may regulate abortion in ways that protect the woman's health. And in the third trimester, when the fetus could potentially survive outside the womb, the state may restrict or prohibit abortion, provided that exceptions are made to protect the woman's life or health. The Roe decision effectively legalized abortion across the United States, immediately nullifying restrictive laws in dozens of states. More than just a change in policy, the ruling became a cornerstone in global discussions on bodily autonomy and reproductive rights. It emphasized that the human body is not simply the object of medical intervention, but something each person has the right to control. Whether and when a woman chooses to have children became a constitutionally protected personal decision, not one that the government could dictate. However, the decision was also met with decades of controversy and opposition in the U.S. Opponents argued that abortion raises profound questions about the ethics of life and should be more strictly regulated. Supporters emphasized personal liberty and gender equality. Over the years, Roe v. Wade became one of the most polarizing issues in American politics and law. Then, in 2022, the Supreme Court overturned Roe v. Wade in Dobbs v. Jackson, returning the authority to regulate abortion to individual states. Despite its reversal, the impact of Roe remained significant. For nearly half a century, it shaped legal debates around reproductive autonomy, privacy, and gender equality, and encouraged countries around the world to re-examine their own abortion laws and protections for women's rights. At its core, Roe v. Wade affirmed a powerful idea, that individuals should have the right to make decisions about their own bodies and the direction of their lives. In the broader context of medical law, Roe was not just about abortion. It was a constitutional affirmation of the principle of bodily autonomy. In 1990, the United States Supreme Court heard a case with far-reaching implications. Cruzan v. Director, Missouri Department of Health. The case centered around Nancy Cruzan, a young woman who, at age 23, was left in a persistent vegetative state after a car accident. Unable to eat on her own, she relied on a feeding tube to stay alive. Her parents believed that Nancy would not have wanted to live in such a condition, and asked the hospital to remove the feeding tube so she could pass away naturally. However, the state of Missouri refused, arguing that there was not enough evidence to prove this was truly Nancy's own wish. The case eventually reached the Supreme Court, which had to decide a difficult question. When a person is no longer able to express their wishes, can their family choose to end life-sustaining treatment on their behalf? In a narrow 5-4 decision, the court ruled that the right to make such decisions belongs to the patient, not the family. The justices affirmed that, under the Constitution's protection of individual liberty, a competent adult has the right to refuse any medical treatment, including life-sustaining interventions. However, if the patient cannot speak for themselves, the state has the authority to require clear and convincing evidence that the patient would have chosen to refuse treatment if they were conscious. Although the ruling didn't give families the direct legal right to withdraw care, it did acknowledge the fundamental right of individuals to choose how their life should end. The case also sparked nationwide discussion about the importance of advance directives, legal documents that allow people to express their medical preferences in writing while they are still mentally capable. These documents can specify whether a person would want interventions like intubation, artificial nutrition, or CPR under certain conditions. Advance directives help guide medical decisions and ease the emotional and legal burden on families during critical moments. Following the Cruzan decision, many U.S. states passed laws promoting the use of advance directives and encouraging individuals to plan ahead while they are still healthy. This shift has strengthened patient autonomy and provided clearer legal guidelines for healthcare providers facing end-of-life situations. The Cruzan case marked a turning point in medical law. Prolonging life was no longer seen as just a medical option, but as a personal choice grounded in values and dignity. It pushed society to confront the question of how life should end, and how the law and healthcare systems can honor that choice. It reminded us that death is not merely a medical outcome, it is a deeply personal decision that deserves respect. In medical law, one of the most common and practically significant questions is this: when a healthcare worker makes a mistake while doing their job, should the medical institution also be held responsible? This is the core idea behind vicarious liability. Vicarious liability means that an employer can be legally responsible for the wrongful acts of its employees as long as those acts occur within the scope of their employment. In a medical context, this means that if a hospital's doctor, nurse, or other staff member causes harm to a patient while performing their duties, the hospital itself may be held liable, even if the hospital didn't directly commit the error. There are both practical and fairness-based reasons behind this legal principle. First, medical institutions usually have greater financial resources and insurance coverage, which makes them better positioned to compensate injured patients. Second, hospitals are responsible for managing medical operations, establishing training systems, and hiring qualified personnel. If an internal system failure contributed to the error, holding only the individual practitioner accountable may not reflect the full picture of what went wrong. Of course, vicarious liability doesn't apply in every situation. The key question is whether the error occurred within the employee's professional duties. For example, if a doctor treated a patient privately during their personal time and outside the hospital system, the hospital typically would not be held liable. Additionally, if the doctor is not a hospital employee but an independent contractor, liability depends on the specific contract terms and the degree of control the hospital exercises over their work. Overall, vicarious liability is not only a tool for protecting patients, it's also a powerful legal incentive for healthcare institutions to strengthen internal risk management and quality oversight. Through this legal framework, medical law holds both individual professionals and organizations accountable, shaping a more complete and responsible system for patient care. When we look back at the development of medical law, we see that it has never been a fixed set of rules. Instead, it's a legal field that continually evolves, shaped by changes in society, advances in technology, and shifting values. From the early 20th century Jacobson case, which established the government's authority to limit individual freedoms during public health crises, to the Schloendorff case, which first emphasized a patient's right to decide what happens to their own body, and onward to the post-war Nuremberg Code and the Canterbury case, which laid the ethical and legal foundation for informed consent, we can trace a clear progression. Medical law has moved from merely protecting patients from harm to empowering them with the right to choose and take control. Later, Roe v. Wade elevated bodily autonomy to a constitutional level, while the Cruzen case expanded this concept to include end-of-life decisions, affirming the importance of advance directives. The Tarasoff case reminded us that patient privacy is not absolute, and that public safety may sometimes take precedence. These landmark decisions didn't just shape American medical law, they profoundly influenced how the world understands the relationship between ethics and healthcare law. Now, in the 21st century, emerging technologies and global events have brought a new wave of challenges to medical law. How should artificial intelligence be integrated into clinical decision-making? Where should we draw the line with gene editing and reproductive technologies? During pandemics, can governments mandate vaccines, restrict movement, or track personal health data? These questions have no simple answers, but they all point to one essential truth. At the heart of medical law is the human being. No matter how advanced the technology or how complex the system, the law must ultimately return to the task of respecting human will, protecting human dignity, and safeguarding basic rights within medical settings. The history of medical law is more than just a series of court rulings or legislative updates. It's a reflection of how modern society understands the body, life, and responsibility. It continually reminds us that good healthcare isn't only about effective treatment. It's about a relationship built on trust, knowledge, and choice. And the role of the law is to provide a clear, stable, and respectful framework for that relationship, so that every person, when facing health and illness, has the space to speak, to decide, and to be heard. That's it for today, and I'll see you in the next episode.